Hello, everybody. I am Golnish Hakim Devar, and I am a professor at Northeastern University. I'm excited to have this conversation with Jonathan Sitek, who is a doctoral candidate at Northeastern University's College of Professional Studies in the Doctor of Law and Policy program. He's currently researching, the title of his research is Sentencing of Child Pornography Offenders in Federal Court, Analysis in the District Court of the Second Circuit. Jonathan has, his background is in justice administration and has been working in federal courts as a probation officer for close to 15 years. So extensive background, and he's using his background for his research. This conversation will be, hopefully will give us a better view of his research and his work. So I'm excited to have Jonathan join me today. Welcome, Jonathan.
Thank you. Pleasure to be here.
And Jonathan, so starting off, I was wondering if you can tell us a little bit about your background and what brought you to your doctoral program.
Sure. As a probation officer, I have pretty significant involvement with the court, and I'm able to observe the justice process in action. And what I've come to see is that sometimes judges have a difficult time trying to decide what they want to do. And as a probation officer, part of our role is actually to recommend what judges should do. Now, they don't have to listen to us, of course. They're the judge, they make the decision. But
Right.
we have a significant role in recommending. And I realized that there might be a way for me to improve the types of recommendations that I'm making to the judges. So as I started to look through the types of education or training that I might be able to undertake, I found the DLP program, the Doctorate in Law and Policy, which sort of merges that area between law and public policy that I thought might be helpful in my role in extending and furthering my education, but also being applicable to the job that I was doing.
Mm-hmm. So that's amazing, and you are finding yourself now working on your thesis and really getting much deeper into your studies, and not only reading but also starting your I assume your data collection. So I am curious what you have found, one, the most promising, and two, the most surprising about your research, and then also your own approach to how you're conducting your research and how you're moving forward this work.
Sure. Initially I had this idea of maybe sitting in courtrooms and observing what was going on and trying to tie in maybe some of the language that was being used in the courtroom with some nonverbal reactions and things of that nature. But we are in the COVID crisis, and because of that, I had to alter my approach to how I wanted to research the topic. And let me say that sentencing disparity in general, I realized is a huge area of research. There's tons of scholarship out there, most of which has taken a quantitative approach. And I've found some, but not a lot, of qualitative studies. And in fact, some of the research I was reading indicated that maybe some areas of exploration could be in that qualitative type area. So as I started to reframe and reshape the approach I wanted to take, it's come down to essentially a transcript analysis. Probably the biggest and most exciting thing for me was that after obtaining my second reader, who's an expert in the field of sentencing disparity, realized that the approach that I've taken hasn't really been done before. So for me, it was exciting in that it's a little more than filling in a gap in the research, because it's not, they're light in this area, or not a lot of people have looked at it. It doesn't look like anybody's really tried to analyze the issue in the way that I'm going to. And what that's done is sort of turned my research question into more of a methodological investigation. Will this even work, what I'm trying to do? And that's exciting to me because we don't really know until the project is complete. So it's gone from asking a very simple question about how judges might decide and what might be influencing them, to more of a methodological investigation as to, gee, why hasn't this method really been used? Why haven't people published a lot in transcript analysis? So that's exciting to me, and it's opened up much broader areas for further investigation after I'm done with this program.
And are you at a position to tell us a little bit more about your preliminary findings about sentencing disparity and some of the discussion that you have discovered about how the approaches are currently at use, or even the quantitative studies that you mentioned, what the findings have been on sentencing disparity studies related to child pornography cases?
Sure. So I should mention that I'm looking specifically at the child pornography cases because that seems to be an area where I think people in general, regardless of their role in the system or as members of the public, have a difficult time. I mean, there's a sort of visceral response to that, and that it is one of our more heinous types of crimes, right? Because we're dealing with children and we're dealing with issues that children should never be exposed to. So how do you balance that visceral response with a fair administration of justice? And in my literature review process, I realized that the area of child pornography itself is where there's probably the most disparity of any types of case in the federal system. So by disparity, for those who don't know, what I'm talking about is one judge may give a very high sentence and another judge may give a very low sentence in a very similar type case. So why is that, and how do we, well, first of all, should we resolve that? And second of all, how do we resolve that? So child pornography sentencings have the highest variances from the recommended sentencing guidelines, as I've learned in my research. So that's why I'm focusing on that area in particular. As far as what I've seen so far in sentencing disparity research, through my literature review and many of the studies I've read, there are differences between, say, Black defendants and white defendants, or judges of certain ethnicity versus white judges. The data tend to show that there are disparities in the cases where sentences are handed out. The question is why? And that hasn't really been explored yet. So by taking a qualitative approach and looking at what the judges are saying in their explanations, we may be able to find some clues either to answer those questions or certainly to open the door to follow up studies in the future when I'm done with my research.
It sounds very, very exciting. Another question more related to your study and your findings, the disparity that you're mentioning, the high sentences versus low sentences, those are within the guidelines still, or do the judges go beyond the guidelines that exist for sentences?
Sure. Part of the problem is that judges are going outside of the guidelines. The guidelines used to be mandatory. When they first came out, the sentencing guidelines were devised primarily as a way to sort of level the playing field so that across the country, and it didn't matter where you were sentenced, a defendant could reasonably expect a sentence within a particular range. Those guidelines are no longer mandatory. The Supreme Court has said you can't do that. So they are recommended sentences for judges. So judges are free to not really ignore them. They have to consider them, but judges are free to sentence within or outside of those guidelines. So that makes the research into sentencing disparity even more difficult because it is a wide open playing field now. And we do have lots of scholarship in the area of the guidelines themselves. Have they leveled the playing field? Have they reduced disparity, or haven't they? And we have lots of research into what other factors besides the guidelines are being looked at, and that typically falls within demographics or identifiers as far as judges go. Other researchers have looked at the demographics and characteristics of the offender. Other researchers have looked at legal factors, what processes in the legal system or structure of the legal system itself may be contributing to disparity. So we have multiple streams of analysis going on within the broad umbrella of sentencing disparity. And I've chosen a very tiny little piece to take a look at, hoping that there might be clues. And perhaps one of the areas I'm excited about is that maybe if I do find something in these analysis that I'm conducting, it may either refute some research that's out there or support some of the conclusions that some of the quantitative studies have shown. So they may have come up with, and I'm making this up now, a statistically significant difference between, I don't know, white offenders and a non-white offender. And the data shows that that's true. Perhaps my study can show, here's why that might be happening through an analysis of what's being said in the courtroom.
Yeah. So that's actually a really great topic and a wonderful area of study, really showing from not necessarily from the defendant's perspective, but from the judiciary's side to analyze the sentencing guidelines to see what that judicial decision-making process looks like. And it seems that the transcript studies may shed some light on that. And what is your hope long-term? What do you hope to achieve after the completion of your research and once you have submitted your material for that final review? What is your goal?
Well, the immediate goal is to maybe learn something that can help me be a better resource for our court and be able to share some of my findings with them. You know, and this is not to be taken as a critique or criticism of the judiciary or the judges themselves. This is an academic, you know, investigation into this area, but hopefully I may pick up on some clues that either I can use myself or share with my staff that can make them a better resource as the judges ask for our recommendations. We might be able to have a little bit more knowledge when we make them. The long-term goal is that perhaps if I do find something significant here, is that it could be a much broader experience for the judiciary, and that if I could bring this forward either to judges or the judicial branch itself, there may be some policy changes or at least some informational resources that could go to the judges to help them see what's going on, and they may be able to adjust their processes to have a little bit less disparity.
This is incredible research, and I'm very excited to see the findings really, and I think it will be quite useful, hopefully for long-term policy change as well as you mentioned, immediate use. I appreciate you joining me on this conversation and telling us a little bit more about your research and shedding some light on work that is unique and is going to add value to current research in this area. And I wish you all the best and happy holidays. If you have any last minute comments for whoever is viewing this video, I would like to invite you to share that before we say our goodbyes.
Sure. You know, I will pitch the program, the law and policy program, in that the scholar practitioner model was the right fit for me rather than the traditional research-based doctorate. And that is because as a working professional, I have to merge what I do for work, or try to merge what I do for work, into my research study. And this was a great way to do it, where I'm getting that doctoral education, but I'm immediately able to apply it into what I'm doing. So I find the program very valuable and useful, and I certainly do not regret my decision in any way. I'm rather enjoying the process.
That's great to hear. Thank you so much.
Thanks
for joining me, Jonathan. Have a wonderful day, and farewell to everyone.
Thanks, you too.